We believe our legal system is built on a foundation of reason. But that foundation has a secret trapdoor, and the password is, "That's too weird to be a lie." There exists a strange dimension of justice where the most effective defense isn't a clever alibi, but an excuse so bizarre it breaks the jury's perception of reality. We're about to explore 50 historical cases where defendants made arguments so insane, they were actually believed. This isn't a collection of loopholes, it's a testament to the power of pure, weaponized absurdity. 1. In 1978, former city supervisor Dan White didn't just snap, he planned. He snuck into San Francisco City Hall through a window to bypass metal detectors and executed Mayor George Moscone and Supervisor Harvey Milk. The act was cold and calculated, but in court, his lawyers painted a picture of a man unraveled by depression, and their star exhibit was his diet. He'd abandoned his healthy lifestyle for junk food, specifically Twinkies and Coke. The media dubbed it the Twinkie Defense, but the real argument was diminished capacity. They claimed the sugar rush was a symptom of a deeper mental collapse, not the cause. A jury bought it, reducing a double murder charge to manslaughter. The city erupted in riots. 2. Most of us think of sleepwalking as that quirky, harmless thing you see in comedies. But what if it wasn't harmless at all? In 1987, a Canadian named Kenneth Parks woke up, not in his bed, but at a police station with bloody hands, telling the officers, "I think I have killed some people." He had. He'd driven 14 miles to his in-laws' home, killed his mother-in-law, and nearly killed his father-in-law. His defense was so audacious it sounded fictional. He was asleep for the entire ordeal. Medical experts confirmed he had a severe sleep disorder, no motive, and a history of sleepwalking. The jury faced an impossible question. Can you convict a man who wasn't there mentally? Their answer was no. He was acquitted of everything. 3. What if someone could literally program you to commit a crime, like a human remote control car, and you wouldn't even remember doing it? It sounds like a plot from a Cold War spy thriller, but it's the basis of the hypnosis defense. The argument is that the defendant's free will was completely overwritten by a third party, turning them into an unwilling puppet. They didn't commit the crime. They were merely the weapon used by the true mastermind, the hypnotist. In a famous 1951 Danish case, a man robbed a bank and killed 2 people, claiming he was under a hypnotic spell cast by his former cellmate. The court was so intrigued that they had him hypnotized in front of the jury. The demonstration was convincing enough that the puppeteer got a life sentence, while the puppet got a far lesser one. 4. You know, it's tough being a rich kid. You have so much money you just don't understand that actions have consequences. At least that was the argument for 16-year-old Ethan Couch in 2013. After killing 4 people while driving with a blood alcohol level 3 times the adult limit, his lawyers brought in a psychologist who claimed Couch suffered from Affluenza. They argued his wealthy parents had coddled him so much he was incapable of linking his behavior to its deadly results. It was a condition born of privilege. In a decision that made the entire country furious, the judge agreed, sentencing him not to prison, but to just probation and a stay at a cushy rehab facility. 5. What if your own hand had a mind of its own, and that mind was a criminal? It sounds like something out of a horror movie, but it's the bizarre reality of alien hand syndrome. This is a rare neurological disorder where a person's hand acts completely independently, without their conscious control or awareness. Sufferers have reported their alien hand unbuttoning their shirt, slapping them, or even trying to choke them. This has become a mind-bending legal defense. Imagine being accused of shoplifting, but your defense is that your alien hand grabbed the item and stuffed it in your pocket while your conscious mind watched in horror, unable to stop it. In a few documented cases, this defense has been presented in court, arguing that if the defendant's own brain isn't in control of their limb, they cannot possibly have the criminal intent required for a conviction. 6. Picture this. You're a defense attorney in Italy. The evidence against your client is overwhelming. He's almost certainly going to jail. What's your last-ditch, absurd Hail Mary play? You argue that your client is simply too ugly to receive a fair trial. I'm not joking. A man convicted of molestation appealed his case on the grounds that his unattractiveness inherently biased the all-female court against him. He claimed they were so repulsed by his appearance that they couldn't possibly be objective. The most insane part? The appellate court agreed, overturned the conviction, and ordered a retrial, giving legal weight to the idea that being ugly is a procedural disadvantage. 7. Imagine being arrested for a crime only to find out it was committed by a completely different person who happens to live inside your own head. This is the incredible legal puzzle presented by the dissociative identity disorder defense, once known as multiple personality disorder. The core of this defense is that the primary personality, the one on trial, had no knowledge or control over the actions of another, alternate personality, or alter. In the famous 1970s case of Billy Milligan, who was charged with several serious crimes, his lawyers argued that 2 of his 24 distinct personalities were the real culprits. Billy himself was just an innocent bystander in his own body. After extensive psychiatric evaluation, the court agreed, finding him not guilty by reason of insanity, making it one of the first major cases where this defense was successfully used. 8. Sometimes the most effective legal strategies don't come from Harvard Law, but from the creators of South Park. In a famous episode, the character of Johnny Cochran wins a case by confusing the jury with a nonsensical rant about Chewbacca, the Wookiee from Star Wars. It had nothing to do with the case but was so convoluted it broke the jury's brains. Real-life lawyers saw this parody and recognized a genuine tactic. Now known as the Chewbacca defense, it's an unofficial term for bamboozling a jury with irrelevant information, red herrings, and complex jargon when the actual evidence is not on your side. It's the art of winning by creating chaos. 9. On a cold night in Florida, police finally cornered a driver named Michael Dickerson after a brief chase. He pulled over but then refused to get out of his car, locking the doors. Frustrated and looking for a way in, one of the officers, John Jones, decided to try a creative solution. He popped the trunk and climbed inside, thinking he could force the doors open from within. But at that exact moment, Dickerson hit the gas, starting a second high-speed chase, this time with a police officer bouncing around in the trunk. When he was finally caught, one of the charges was kidnapping. His lawyer's defense was simple and brilliant. You can't kidnap someone who voluntarily climbs into your trunk. In a widely reported decision, the judge agreed, dismissing the kidnapping charge on the grounds that the officer had essentially kidnapped himself. 10. The year is 1981. A family in Connecticut is tormented by a demonic presence that has allegedly possessed their 11-year-old son. Famed paranormal investigators Ed and Lorraine Warren are called in to perform an exorcism. During the ritual, a family friend named Arna Johnson taunts the demon, inviting it to leave the boy and enter him instead. Months later, Johnson stabs his landlord to death. His lawyers prepared a defense never before attempted in an American court. The devil made me do it. They argued Johnson was not in control, that he was possessed by the very demon from the exorcism. While the judge ultimately rejected the defense as unprovable, the sheer spectacle dominated the trial, and Johnson was convicted only of manslaughter, not murder. 11. Imagine growing up in a neighborhood so relentlessly violent that your brain rewires itself for pure survival. This isn't a hypothetical, it's the basis for the urban survival syndrome defense. In a high-profile case from 1994, 2 brothers from a brutal Washington, D.C. neighborhood shot and killed a man they perceived as a threat. Their lawyer didn't argue self-defense in the traditional sense. Instead, he presented a powerful case that their upbringing, filled with witnessing murders and constant threats, had given them a form of PTSD, conditioning them to react with preemptive force. They weren't acting out of malice, he argued, but from a deeply ingrained battlefield mentality. The jury was profoundly moved by this context. While they didn't walk away free, the defense was successful enough to spare them a murder conviction, resulting in a verdict for the much lesser charge of manslaughter. 12. Here is a defense rooted in a simple, almost pastoral truth. All sheep look pretty much alike. A man was accused of stealing a valuable flock of sheep from his neighbor. The evidence was strong and a conviction seemed certain. But his lawyer devised a brilliant piece of courtroom theater. He brought a single, ordinary sheep into the courtroom, a sheep that looked identical to the ones that were stolen. He then challenged the accuser to step forward and pick his stolen property out from an imaginary lineup. The owner, flustered, had to admit he couldn't be 100% certain. The lawyer then turned to the jury and argued, "If the owner can't even definitively identify his own property, how can you, the jury, be sure beyond a reasonable doubt that the sheep in my client's possession are the stolen ones?" The case was dismissed. 13. Imagine you get a minor traffic ticket, and instead of just paying the fine, you show up to court, slam a gauntlet on the table, and demand the right to settle the matter by fighting the government clerk to the death with broadswords. This sounds like a scene from a fantasy movie, but in 2002, a 60-year-old mechanic in the UK actually tried it. He received a small fine for an administrative error, and, after doing some research, discovered that the medieval law allowing for trial by combat had never been officially abolished. He formally challenged the driver and vehicle licensing agency to a duel with samurai swords, Gurkha knives, or sledgehammers. The court was completely stunned and had to adjourn to figure out if this ancient right was still legally valid. He ultimately won, not by fighting, but because the system found it easier to just drop the $25 fine than to deal with the legal paradox he had created. 14. Sometimes a crime in one culture is a tradition in another, and when those two worlds collide in a courtroom, things get complicated. This is known as the cultural defense. In a landmark case from the 1980s, a Hmong immigrant from Laos was charged with kidnapping and assaulting a woman. His defense was that he was performing a zij poch niam, a traditional form of courtship that looks alarmingly like abduction to Western eyes. His lawyers argued he had no criminal intent. He was simply following the cultural customs he had always known. The court, recognizing the immense cultural gap, showed leniency, allowing him to plead to a lesser charge with a minimal sentence. 15. What if your own body was a secret, illegal brewery, turning every slice of bread you eat into alcohol and you had no idea? It sounds like science fiction, but it's a real and terrifying medical condition called auto-brewery syndrome. People with this condition have an overgrowth of yeast in their gut that ferments carbohydrates into ethanol. They can become legally intoxicated just by eating pasta or potatoes. This has led to one of the most foolproof DUI defenses ever. Imagine being arrested, blowing a 0.20 on a breathalyzer, and swearing to the officer you haven't had a single drink. No one believes you. But when doctors finally diagnose this incredibly rare syndrome, it completely changes the game. It's the ultimate form of involuntary intoxication, and in multiple documented cases, it has led to DUI charges being completely dismissed. 16. What if the snack aisle at your local grocery store could be blamed for a major crime? It sounds absurd, but it's not far from the sugar rush defense that gained traction in the UK. A man was charged with a violent assault after attacking someone in a fit of rage. His lawyer didn't argue insanity or self-defense. Instead, he argued that the man suffered from a severe case of hypoglycemia, dangerously low blood sugar, that was triggered by binging on sugary snacks. An expert testified that this physical condition could lead to aggression, confusion, and a complete loss of self-control. The court was persuaded that his brain was literally starved of fuel, making him not criminally responsible for his actions. He was acquitted, all thanks to a can of soda and a chocolate bar. 17. We've all had those incredibly vivid dreams that feel completely real for a few confusing seconds after we wake up. But what if your body decided to act out those dreams physically while your conscious mind was still completely offline? This is the core of the parasomnia defense. In a bizarre case from Wales, a man was found in a stranger's home, seemingly in the middle of a burglary. His explanation was that he was having an intense nightmare about being in a video game and was simply carrying out the actions from his dream. It sounds like a ridiculous excuse, but medical experts testified that he had a severe sleep disorder where the brain's off switch for the body during sleep doesn't work. His mind was asleep, but his body was awake and on autopilot. The jury was convinced he had no conscious control over his actions and acquitted him. 18. When you get arrested, there are many things you can claim to be: a victim of circumstance, innocent, or even insane. But a man in Texas went for a truly unique identity. He claimed to be a 500-year-old vampire who needed to feed on human blood. He wasn't joking. During his trial for assault, he consistently maintained this belief. His defense wasn't just about claiming insanity, it was about living in a completely different reality. The psychiatric evaluation confirmed his profound delusion, and the jury found him not guilty by reason of insanity, presumably because the legal system has no jurisdiction over the undead. 19. The rotten social background defense argues that a person's upbringing was so filled with poverty, abuse, and neglect that they never had a chance to develop a proper sense of right and wrong. It was first proposed in the 1970s for a defendant who had endured an unimaginably horrific childhood. The lawyer argued that society itself was a co-conspirator in the man's crimes by allowing him to be raised in such a toxic environment. While it has never led to a full acquittal, it has been successfully used to convince juries to opt for lesser charges, like manslaughter over murder. 20. It's a plot twist so old it's practically a fossil. The evil twin who frames their virtuous sibling for a crime. But what happens when this soap opera fantasy smashes into the rigid reality of a courtroom? You get one of the most brilliant legal loopholes imaginable. The entire foundation of a criminal trial is that the prosecution must prove, beyond a reasonable doubt, that the defendant sitting right there is the person who committed the crime. But if that defendant has an identical twin, the whole system can short-circuit. Imagine eyewitnesses saw one of them at the scene. Imagine forensic evidence is found, but it could match both brothers. This isn't a psychological defense. It's a factual nightmare for the prosecution. In several real cases, charges for everything from theft to more serious crimes have been dropped simply because authorities couldn't definitively prove which of the two identical siblings was the culprit. It's the ultimate get-out-of-jail-free card, provided you were born with a perfect alibi. 21. Remember that scene in The Matrix where Neo learns the rules can be bent? Well, some people took that philosophy and ran with it straight into a courtroom. The Matrix defense is a real, albeit rare, insanity plea where defendants claim they committed a crime because they believed they were living in a computer simulation. In Ohio, Tunda Lynn Ansley shot and killed her landlady, arguing that she wasn't killing a person, but rather freeing herself from the Matrix's control. The jury found her not guilty by reason of insanity, essentially agreeing that she genuinely believed reality was a fabrication. A bizarre case of life imitating art. 22. For most of history, PMS was dismissed as little more than a punchline. But in 1980s Britain, a couple of lawyers decided to take it deadly seriously. Enter Sandy Craddock, a barmaid with a long history of violent crime. After stabbing a co-worker to death, her defense team argued she was not a murderer, but a victim of a cripplingly severe form of premenstrual syndrome that triggered diminished responsibility. A doctor testified her hormonal imbalance was like a boiling pan with the lid on it. The court was persuaded. Her murder charge was reduced to manslaughter, and she walked away with probation, contingent on continued hormone therapy. 23. Let's just be direct. A man in Washington was charged with exposing himself to a woman. The evidence seemed clear. His defense, however, was so stunningly bizarre, it left the courtroom speechless. His lawyer argued that the defendant's endowment was so minuscule, it could not possibly meet the legal definition of exposing himself. The jury, after what must have been the most awkward deliberation in legal history, found the argument compelling and acquitted him. 24. Can you be found guilty of a crime that was literally impossible to commit? In the 17th century, a French woman was accused of witchcraft, with the primary evidence being that she had been seen dancing with the devil himself at a witch's Sabbath. The case seemed grim. However, her lawyer came up with a defense of pure, undeniable logic. He argued that for his client to have met the devil must, in fact, exist. But if the devil exists, he is a fallen angel, a spiritual being. And as a spiritual being, he would be incapable of the physical act of dancing. Therefore, the star witness's testimony was a physical impossibility. This theological loophole defense was so perfectly reasoned within the beliefs of the time that the court was stumped. The case fell apart, and the woman was set free, not by denying witchcraft, but by proving the devil had 2 left feet. 25. Everyone knows you have the right to remain silent. But do you have the right to remain a mime? In 2012, a street performer in New York City known for his mime act was arrested for aggressive panhandling. When he was brought in for questioning, he refused to speak. He didn't say he was invoking his Fifth Amendment right. He simply continued his performance, pretending to be trapped inside an invisible box. He maintained this silent, artistic protest throughout his entire arraignment, frustrating the judge, the prosecutor, and the court officers to no end. Ultimately, the judge had to drop the charges because it was impossible to conduct legal proceedings with a defendant who was, for all intents and purposes, a living, silent work of art. 26. What's the one thing that can stop a speeding ticket in its tracks? According to one man in Switzerland, it's the sheer, overwhelming power of a good sneeze. A driver was caught on camera going well over the speed limit. The case seemed open and shut. However, his lawyer presented a novel defense: sneeze-induced acceleration. He argued that his client was struck by a sudden, violent sneezing fit just before the speed camera. This involuntary convulsion caused his leg to spasm and press down hard on the accelerator, making the car lurch forward uncontrollably. While it sounds like a desperate excuse, medical experts were brought in to testify that such a powerful, involuntary reflex was indeed possible. The court, finding the explanation plausible, acquitted him. 27. Of all the things that could cause you to lose control of your car, a bee sting is probably not at the top of your list. But for one woman, it was the key to her freedom. She was driving when a bee flew into her car and stung her, causing her to panic, swerve, and crash into another vehicle. She was charged with reckless driving. In court, her lawyer argued that the sudden sharp pain of the sting triggered an involuntary reaction, a state of automatism. She wasn't driving recklessly, she was simply reacting to a sudden medical event. The judge agreed that her response was an uncontrollable reflex, not a conscious choice, and dismissed the charges. 28. During the Middle Ages in France, the law had a very peculiar loophole. A person convicted of a capital crime could be sentenced to hang, but the sentence had to be carried out within 24 hours. A clever coffin maker, who had been sentenced to death, used this to his advantage. When the executioner came to collect him, the coffin maker refused to go. His defense? He was the only coffin maker in town, and he had not yet built his own coffin, which was his right. Because he couldn't build it within the 24-hour deadline, the execution couldn't legally proceed. The officials were so stumped by this logical paradox that they had to let him go. 29. Jules Lowe, a man from Manchester, woke up one morning and began brutally attacking the woman in his bed, believing she was a giant, threatening spider. When police arrived, he was still in a state of terror, trying to fight the imaginary creature. His defense was that he wasn't truly awake. He was experiencing a hypnagogic hallucination, a terrifyingly vivid dream state that bleeds into reality upon waking. He wasn't attacking a person. In his mind, he was fighting for his life against a monster. A sleep expert confirmed the condition was real, and the court found him not guilty, concluding his brain had committed the crime without his conscious participation. 30. Sometimes the most effective defense is to argue that you're simply too stupid to be a criminal mastermind. In 1995, MacArthur Wheeler robbed 2 banks in broad daylight without a mask. When police showed him the security footage, he was genuinely shocked. Why? Because he had covered his face in lemon juice. He believed that since lemon juice is used as invisible ink, it would make his face invisible to cameras. This wasn't an insanity plea. He was just profoundly, bafflingly mistaken. His sheer incompetence became a cornerstone of what psychologists now call the Dunning-Kruger effect. where people are too incompetent to recognize their own incompetence. 31. You wake up in a jail cell with no memory of how you got there. The police say you committed a terrible crime yesterday, but to you, yesterday is a complete blank. How can you possibly defend yourself against something you can't remember? This is the legal labyrinth of the amnesia defense. It's not an argument of innocence, but of incompetence. Lawyers argue that a defendant with genuine amnesia cannot meaningfully assist in their own defense. They can't offer an alibi or challenge the prosecution's story. In many cases, this doesn't lead to an acquittal, but it can result in the trial being postponed indefinitely until the person's memory returns, leaving them in a strange legal limbo. 32. Music festivals are a marathon of chaos, and nowhere is that more obvious than the endless, desperate lines for the portable toilets. For one man in Australia, this logistical nightmare became the stage for a crime of pure, unadulterated desperation. After what was presumably a very long wait, he saw his window of opportunity not as an open toilet, but as a temporarily unattended one. The problem was, it wasn't unattended, it was occupied. Undeterred, he grabbed the entire plastic outhouse and began dragging it away, with a very confused and justifiably terrified person still inside. When police inevitably caught up with him, his defense in court was a masterpiece of absurd logic. He argued it wasn't theft. It was an emergency relocation, a desperate act of problem-solving because the line was simply too long and his biological need too great. The judge, faced with one of the most ridiculous cases to ever cross his desk, ultimately saw the human, if not legal, side of the story and let him off with a stern warning. 33. Patriotism can be a powerful motivator, but can it be a legal excuse for murder? In 1859, a prominent New York congressman named Daniel Sickles discovered his wife was having an affair with the district attorney, Philip Barton Key, who happened to be the son of the man who wrote The Star-Spangled Banner. Sickles confronted Key in broad daylight across from the White House and shot him dead. At his trial, Sickles' defense team pioneered a novel strategy: temporary insanity. They argued that the dishonor of the affair drove him into a patriotic rage, making him morally, if not legally, justified. It was the first time this defense was ever used successfully in the United States, and the jury set him free. 34. Can a pet parrot become a star witness in a murder trial? In 2015, a man named Martin Durham was killed in his home. The police had few leads until they started listening to Bud, the victim's African gray parrot. The bird kept repeating in what sounded like the victim's voice the phrase, "Don't effing shoot." The prosecutor seriously considered putting the parrot on the witness stand. While a judge ultimately didn't allow it, the parrot's testimony was so compelling and widely reported that it heavily influenced the case against the man's wife, who was later convicted of his murder. 35. What happens when the punishment for a crime is arguably more dangerous than the crime itself? This was the exact dilemma a court in the UK faced with a man weighing nearly 500 pounds who was sentenced to prison time. His lawyer didn't argue his client's innocence. Instead, he argued that the very act of imprisoning him would be a potential death sentence. He presented a compelling case that the man's severe obesity and complex array of health problems, requiring specialized equipment, a strict diet, and constant medical monitoring, were far beyond what the prison system was equipped to handle. Sending him to jail, the lawyer claimed, would constitute cruel and inhumane punishment, a guaranteed case of severe medical neglect by the state. The judge was put in a difficult position: uphold the sentence and risk a man's life, or find another way. In the end, the logic was undeniable. The man was, quite literally, too fat for prison. His sentence was commuted to house arrest, a rare case where a person's physical reality fundamentally broke the system of justice. 36. We've all been told to drink more water for our health. But can you drink so much water that it turns you into a temporary criminal? The answer is yes, and it's a defense known as water intoxication. In a bizarre case, a woman began acting erratically and committed an assault. She had no history of violence or mental illness. Her lawyers discovered she was on an extreme health diet that required her to drink gallons of water a day. This induced a rare medical state called hyponatremia, where sodium levels in the blood plummet, causing the brain to swell. This can lead to confusion, psychosis, and a complete loss of control. The court accepted that she was in a state of delirium and not responsible for her actions. 37. If you're being chased by a swarm of angry killer bees, is it legal to break into someone's house to escape? A court in Arizona had to answer that exact question. A couple out for a hike accidentally disturbed a massive hive of Africanized bees and were relentlessly pursued. Fearing for their lives, they broke into a nearby empty cabin to take shelter. The owner later pressed charges for breaking and entering. Their lawyer used the necessity defense, arguing that breaking the law was the only way to prevent a greater harm, in this case, a gruesome death. The judge agreed, ruling that their trespass was justified because any reasonable person would choose a misdemeanor over being stung to death. The charges were dropped. 38. Being a passionate sports fan can sometimes look like a mild form of insanity. For one die-hard Green Bay Packers fan, that line became a legal defense. After the rival Minnesota Vikings beat the Packers, he was so distraught that he went to his Vikings-loving neighbor's house and set his garage on fire. In court, his lawyer argued he was suffering from an extreme emotional disturbance brought on by the devastating loss. It wasn't arson. It was a temporary break from reality fueled by football. While he wasn't completely exonerated, the argument was compelling enough for the jury to convict him of a significantly lesser charge. 39. What happens when the legal system has to rule on a case of self-defense against a ghost? It sounds like a comedy sketch, but it's a real and fascinating corner of the insanity defense. Imagine a man is found violently attacking a friend or family member. To every witness, it's a clear-cut assault. But the man's story is that he wasn't attacking his loved one at all. He was fighting a demonic entity that had possessed their body. In his mind, he wasn't a criminal. He was a hero, a reluctant exorcist in a desperate battle against evil. When psychiatric experts testified that the defendant was experiencing a genuine psychotic delusion and was truly incapable of perceiving reality correctly, this defense can and has worked. The court isn't ruling that demons are real, only that the defendant's belief in them was, and that belief erased any criminal intent. 40. What if the government was so desperate to catch you that they practically committed the crime for you? This is the essence of the entrapment defense. It argues that the defendant only committed the crime because they were tricked, coerced, or persuaded by law enforcement. The most famous example is the trial of auto executive John DeLorean in the 1980s. The FBI, using an informant, lured him into a massive fake illegal deal, filming the whole thing. The evidence looked damning. But his lawyers successfully argued that the government had essentially manufactured the entire crime from scratch, and DeLorean would never have done it otherwise. The jury agreed, and he was acquitted of all charges. 41. We all have our hobbies, but what happens when a hobby completely takes over reality? In 2011, police in Oregon were called to a parking lot to deal with a man wildly swinging a plastic lightsaber and attacking random cars and shoppers. When they arrested him, he didn't offer a typical excuse. He calmly explained that he was a Jedi Knight, and he was simply practicing his combat forms against the Sith, who were hiding in plain sight. This wasn't a joke. His lawyer successfully used this as the foundation for a powerful insanity defense, arguing that his client was living in a Star Wars fantasy so complete and immersive that he was incapable of distinguishing between a suburban parking lot and a galactic battlefield on Coruscant. He was found not guilty by reason of insanity. 42. What if your very DNA was your accomplice? This is the controversial and unsettling frontier of the genetic defense. The most prominent case involved Stephen Mobley, a man convicted of murder in the 1990s. During his appeal to avoid the death penalty, his lawyers argued that Mobley wasn't entirely to blame for his violent actions. They claimed he carried a specific genetic variant, a mutation in the MAOA gene, which has been linked in some studies to aggressive and impulsive behavior. They weren't saying he was innocent, but that he was biologically predisposed to violence, a prisoner of his own genetic code. While this specific appeal was ultimately denied, it blasted open a terrifying Pandora's box in courtrooms worldwide, forcing the legal system to grapple with the question, where does free will end and biological destiny begin? 43. We've all felt that drowsy, unproductive slump after a big lunch. But for one British man, that food coma became a legitimate legal alibi. He was caught red-handed stealing a significant amount of cash from his employer, a seemingly open and shut case. However, his lawyer argued he wasn't a thief, he was simply sleepy. The official defense was postprandial drowsiness, the scientific term for the body's natural slowdown after a large meal. A doctor testified that the man suffered from an unusually severe form of this condition, which caused him to become profoundly disoriented, confused, and susceptible to poor judgment. The court accepted the argument that he was not in a rational state of mind when he took the money and, incredibly, he was cleared of the charges. 44. A woman in North Carolina watched her car go up in flames, and the insurance company was convinced it was arson. They argued she had torched her own vehicle for the payout, a classic case of fraud. Her defense, however, was far more primal: arachnophobia. She testified with genuine, palpable terror that while she was driving, she spotted a large spider crawling inside the car. In a blind panic, she slammed on the brakes and leaped out of the moving vehicle. She then watched in horror as her car, now driverless, rolled down a hill, crashed into an embankment, and caught fire. She didn't burn the car, she argued. A spider had scared her into a freak accident. The jury found her testimony so believable, they acquitted her of all charges. 45. Meet Charles Osborne, a man who holds the Guinness World Record for the longest continuous hiccup attack, lasting an unbelievable 68 years, from 1922 to 1990. While this was mostly a source of personal torment, it once became the centerpiece of an incredible legal defense. In the 1930s, Osborne was put on trial for murder. The prosecution's entire case hinged on the testimony of a single witness, a friend who claimed that Osborne had confessed the whole crime to him. But Osborne's lawyer presented a defense so specific it could only apply to one man on Earth: the chronic hiccup alibi. He argued to the jury that his client, who hiccuped violently up to 40 times a minute, was physically incapable of speaking a single, coherent sentence, let alone a detailed murder confession. The jury was forced to decide which was more likely: that the friend was lying, or that a man who couldn't order a meal without interruption had somehow managed to deliver a clear, multi-sentence admission of guilt. They found the confession medically implausible, and Charles Osborne was acquitted. 46. For centuries, if you were on trial for a serious crime in England, your best defense wasn't an alibi or a witness. It was the ability to read a single sentence from the Bible. This was the benefit of clergy, one of the most powerful and bizarre legal loopholes in history. Originally intended to allow clergymen to be tried in church courts, it evolved into a get-out-of-jail-free card for anyone who was literate. A convicted criminal, even one sentenced to death, could claim this benefit. The court would then present a Bible, opened to Psalm 51:1, the neck verse. If the convict could read it aloud, they would be spared execution, branded on the thumb, and set free. It was a life-or-death literacy test, and countless criminals who couldn't write their own names spent their time in jail desperately memorizing that one single verse to save their necks. 47. Some excuses are timeless. The dog ate my homework. I got stuck in traffic. But in 2003, a man in Washington state took it to a legendary new level after crashing his car into a telephone pole. When police arrived, he confidently explained what had happened. His dog, a pit bull mix, was driving. He claimed he was merely teaching his beloved pet how to operate a vehicle. While the police didn't buy it for a second and charged him with a DUI, the sheer audacity of this defense in a court setting is a masterclass in creative desperation. Though not a full acquittal, the story itself is a legal Hall of Famer. 48. Picture a courtroom in 19th century America. A man is on trial for murder. The evidence is presented, the lawyers give their closing arguments, and the jury files out. They return hours later with a verdict: guilty. The judge slams his gavel and sentences the man to hang. Justice is served. There's just one small problem. Years later, a shocking discovery is made. One of the jurors was not a citizen of the United States, and in fact, wasn't even a legal resident. He was an alien, in the legal sense of the word. The entire case was appealed on the grounds that the jury was improperly constituted, making the verdict legally null and void. In several real historical cases, this alien juror defense has successfully overturned murder convictions, not because of new evidence or a claim of innocence, but because of a single, unnoticed bureaucratic error that invalidated the entire trial from the very beginning. 49. What if you could get charged with a DUI after having nothing stronger than a glass of water all night? It's possible if you happen to be in a car with friends who are enjoying themselves. This is the involuntary intoxication via secondhand smoke defense. In one case, a man was pulled over and failed a sobriety test despite swearing he was sober. His defense was that his car was so thoroughly hotboxed by his passengers that he had become passively intoxicated just from breathing the air. While it sounds like a desperate excuse, he had a scientist testify that it was theoretically possible. This defense has been used successfully in several cases to have charges dismissed, proving that sometimes you really can get a contact high. All right, we have covered 49 journeys into the twilight zone of legal reasoning, and only one remains. But before we get to our grand finale, it's time for the final verdict. In our opinion, the award for the most mind-blowingly brilliant defense on this list goes to the trial by combat, simply because it weaponized pure, uncut historical nerdiness against a modern bureaucracy and won. Do you agree with our verdict? Or did another case, like the auto brewery syndrome, deserve the crown? Let us know in the comments. And now, for our final number. 50. In the world of audacious defenses, this might be the absolute pinnacle of blaming your problems on anything but yourself. Stephen Wrights was a lawyer in Florida who was caught embezzling hundreds of thousands of dollars from his clients. The evidence was irrefutable, a career-ending slam dunk. But Wrights, representing himself, argued that he suffered from a rare condition that forced him to do it: a shopping addiction. He claimed to have an uncontrollable pathological compulsion to buy expensive, luxury goods, and stealing from the people who trusted him was the only way he could fund his illness. He was essentially arguing that he was the real victim, a victim of his own lavish lifestyle and exquisite taste. The sheer audacity of a lawyer using a self-diagnosed, luxury-based addiction to excuse financial crimes is a perfect, almost beautiful encapsulation of the human brain's limitless capacity for self-serving justification. 50 times the fortress of the law was breached not by evidence but by the sheer, unpredictable power of human absurdity. These stories prove that justice isn't always about cold, hard facts. Sometimes it's about the strangest story a jury is willing to believe. We're curious. Had you heard of any of these cases before, or was every single one a new discovery for you? Let us know in the comments. And if you enjoy having your view of the world turned upside down, subscribe and hit that notification bell.